scope and importance of forensic evidence has been increasing over the years. On the evolution and expansion of the technology, new types of crime, such as internet-based crime, computer-aided crime, etc., have emerged as a major challenge to the law enforcement agencies. The advances in science and technology are increasingly enhancing the role of forensic science and scientific aids in criminal investigation. This is a positive trend, as is it strengthens the much needed objectivity of investigation, thereby enhancing the credibility of investigation processes and improving probability of bringing offenders to justice, which amounts to the sustenance of law in the society as well. A very warm good morning, honorable dignitaries, valued guests, most respected chairs, faculties and presenters, valued listeners, students of Law Academy, students from other universities, and all my dear friends. A delightful welcome to one and all to the 10th International Seminar on Credibility of Evidence by Forensic Practices in Crime Investigation, organized by Kerala Law Academy Law College in association with Center for Advanced Studies and Research Culture, which is the research branch of the Law Academy, an autonomous institution with the nominees and representatives of the government. Culture is conducive to ignite nascent thoughts and ideals. Kerala Law Academy, established in 1966 by the legal luminary late Dr. N. Narayan Nair sir, is a seat of excellence in legal education, consultancy, research, and in pioneering law reforms. On this occasion, let us pay our sincere homage to the godfather of this legacy by observing a minute of silence. Thank you all. So next, we have a virtual welcome to one and all to our 10th International Seminar on Credibility of Evidence by Forensic Practices in Investigation.
Kerala Law Academy Law College, in association with Center for Advanced Legal Studies and Research Culture, is organizing a one-day international seminar on credibility of evidence by forensic practices in crime investigation on 8th of January 2022 from the Kerala Law Academy campus, Perukada, Trivandrum.
The Kerala Law Academy Law College, established in 1966, is a center for legal education, legal research, and law reforms. Its acclaimed peer-reviewed journal has been continuously published since 1977.
Law without justice is wounds without cure. Through this seminar, we aim to highlight the consequence, developments, and evolutions in forensic testimony, forensic tools, practices, and techniques in criminal investigation.
This seminar is organized with the intention to bring together academicians, students, scientific experts, and other intellectuals to discuss the various aspects of credibility of evidence by forensic practices. We are delighted to invite you all to our 10th International Seminar.
Well, that was indeed a great welcome. This 10th International Seminar on Credibility of Evidence by Forensic Practices in Crime Investigation aims to offer a comprehensive analysis of forensic practices to help us identify those scientific methods which, when validated and correctly applied, can add immense help to the search for truth in the criminal justice system. Today, we are blessed with the presence of esteemed personalities on this virtual dais. A smile is a universal welcome, and a greeting is a universal embrace. I invite Advocate Nagaraj Narayanan sir, Director, Kerala Law Academy, and member of Bar Council of Kerala, who is a great visionary, our constant source of inspiration, our supporter, and the pillar of strength of this institution, to officially welcome our guest to this inaugural session. Sir, please.
Respected members on the virtual dais and also off the dais. First, let me apologize to all because I am now in Cochin and taking part in the convocation there of the National Law University, National University of Advanced Legal Studies, and there in between there's a small technical snack. That is why I was not able to join earlier. I hope I can be heard. right?
Yes, sir, you're audible.
So most respected Vice Chancellor and other distinguished dignitaries on the virtual dais and off the virtual dais, and other faculty members and dear friends. It's a matter of pride and privilege to welcome the legal dignitaries who have gathered here to take part in the 10th International Seminar on the topic Credibility of Evidence by Forensic Practices in Crime Investigation. In the present scenario, science is expanding at an ever-increasing rate. Forensic science helps in the application of scientific techniques to provide objective and circumstantial evidence. This seminar aims to offer a comprehensive analysis of forensic practices to help us identify those scientific methods which, when validated and correctly applied, can add immensely to the search for truth in the criminal.
Sir, hope that your mic is muted.
Yes. Thank you.
Welcome,
Today's
sir.
session will be presided by Dr. Sindhu Tulasidaran Madam, Head and Associate Professor, Department of Law, University of Kerala. Madam has over 10 years of teaching experience as postgraduate level. Madam is also a graduate in chemistry from where she shifted over to law. On behalf of the Kerala Law Academy, I would like to invite Dr. Tulasidaran Madam, Sindhu Tulasidaran Madam, to this function.
Thank you.
I'm extremely privileged to invite Dr. Mahadevan Pilla Sir, the most honorable Vice Chancellor of the University of Kerala. Dr. Mahadevan Pilla Sir is currently serving as the head of the Department of Optoelectronics in the university. He is also a lifetime member of the Material Research Society of India, Indian Science Congress Association, Optical Society of India, and the Indian Society for Non-Destructive Teaching. On behalf of the Kerala Law Academy, I'm extremely happy and privileged that the most important personality as far as our university is concerned, the head of our university, Dr. Mahadevan Pilla Sir, who is taking so many steps to make our university number one among the universities in Kerala, and who is the visionary. And by the time his sir would complete his term as Vice Chancellor, Kerala University would be going many steps ahead and will be one of the best universities in the whole of India. We are extremely privileged, sir, to have you here as the chief guest for today's function, to inaugurate the function. On behalf of the Kerala Law Academy and delegates and all others present here, I extend to you, sir, a very warm welcome to this function. Welcome, sir.
Thank you.
Now we have Dr. Alexander Jacob, IPS, sir, retired DGP, Nodal Officer, National University of Police Sciences and Security Sciences. Professor Dr. PJ Alexander, sir. Dr. Alexander, sir, is a scholar and trainer who has retired as Deputy Director General of Police. He taught in the postgraduate department of Political Science, University of Kerala, before joining the Indian Police Service in the Kerala cadre. And while in service, he graduated in law and took a doctorate. Dr. Alexander, sir, served as the Chief Executive of several PSUs and Member Secretary of the Kerala Police Reorganization Commission, and is a visiting faculty in various teaching and training institutes. Sir, on behalf of all of us here, delegates and all participants, and on behalf of the Kerala Law Academy, I extend to you, sir, Dr. Alexander Jacob, sir, a very warm welcome. Welcome, sir. Now we have Professor Jiva Nirla, Madam, who is Professor of the Faculty of Law, Department of Public and International Law, University of Colombo. Professor Jiva Nirla, Madam, started a career as an academic at the Faculty of Law, University of Colombo in 1993. Since then, she has held several administrative positions at the university level, including the head of the department Deputy Director Examination, Virtual Campus, University of Colombo, and member of Board of Management of Postgraduate Institute of English, Open University, Sri Lanka, and he is a nominee of the Selection Committee of the University Grants Commission, Sri Lanka. On behalf of the Kerala Law Academy and all those present here and delegates, I extend a very warm welcome to Professor Jeeva Nirila sir. Welcome, madam. Welcome. Next, we have Dr. Bhargav C. Goel, sir, Senior Assistant Professor, National Forensic Sciences University, Government of India. On behalf of the Kerala Law Academy and all delegates here and participants, I extend a very warm welcome to Dr. Bhargav C. Goel, sir, to this function. Now, I would extend a formal welcome to the main architects of this function, the Professor K. Anil Kumar, sir, who is the Director of Student Services in our institution. Then Professor, the principal of this institution, the most important personality as far as this institution is concerned, Professor Harindran K. Then another Professor Ajida Nair of our institution. Dr. Dakshina Saraswati, who is also Professor. Srimati Priya MK and Shalini AP, Assistant Professors, who have been organizing this function so far, and all other faculty members. I extend to all the faculty members and Professor Harindran sir, K. Anil Kumar sir, Ajida Nair madam, Dr. Dakshina Saraswati, Priya MK, Shalini MP, and all other faculty members. A very warm welcome to this function. And finally, I welcome all the students, teaching, non-teaching, and administrative staff to this function, and all the participants to the function. And I understand that more than 40 papers have come, which have been selected. Papers have come, several papers have come, around 100 papers have come, but we have selected only 40 papers, and all the selected participants are here. And I hope that this 40 papers will throw a lot of research material and research for research purpose will help the subject for the development and progress of this subject. And on behalf of the Law Academy and all those present here, I extend to all the persons and trust people and everybody a very warm welcome. Thank you. Thank you very much.
Thank you so much, sir, for your warm welcome. And also, I take this opportunity to welcome you two into the session. Welcome, sir. Now, with immense pleasure and respect, I invite Dr. Sindhu Tulasidaran ma'am, Head and Associate Professor, Department of Law, University of Kerala, for the presidential address. Ma'am, please.
Thank you. Thank you, Gauri. So, first of all, respected Vice Chancellor, Dr. V.P. Mahadevan Pillai, respected dignitaries on and off the dais, dear faculty members, dear students. First of all, I take this opportunity to congratulate the coordinators of the seminar for taking up such a topic which is very relevant in a new world scenario, that is credibility of evidence by forensic practices in crime investigation. And since I have heard that more than 100 papers, isn't it, have come up for presentation and you could select only a very few papers, I'm also happy that many of the members of the academic community are taking initiatives to study on the subject. So it's a good move from the part of the institution. So once more, I congratulate all of you. So you know that you would have definitely read a lot about forensic evidence. It is firstly an application of science. As I said, I also switched over to law from science. So I have a base in science. So it is actually application of law, application of science to law. And we can see how it has been enforced by, it is being enforced by the investigating officers in criminal justice administration. So when we say science, what forensic science helps us is to identify the best scientific methods for assessing evidence, for collecting evidence, for assessing evidence, and also for assessing for that is helping us a lot, that is contributing a lot in assessing the truth in criminal justice administration. So, all part of science is coming in: physics, chemistry, then psychology, chemical engineering, all computer science, other engineering branches, all these are coming in. And for to cite a few instances, in physics, we rely on physics to study about, to understand about the design of blood spatter. And also in chemistry, we rely on chemical science to study about the composition of drugs. Then in biology, we rely on biological techniques to identify the source when there is a chance of unidentified suspect. So that is the importance of science upon law in collecting forensic evidence. So when we say forensic evidence, what we have to do with law, which are the various criteria that we will have to assess before appreciating an evidence. You know that it's not all evidence that we appreciate, that we admit to admit in assessing the legal, admit in assessing the proof in the case of judgments. In the case of delivering judgments, we don't admit all whatever we have as forensic evidence. We only admit proper evidence, that is properly qualified ones. Properly qualified in the sense that those that are given by experts and whose testimony can be admitted as evidence. So properly qualified and admissible expert testimony alone can be considered as forensic evidence. So in regard to law, we can say that when we take up this forensic evidence, the evidence collected by forensic methods, we'll have to first see the legality. So the test for legality is first of all applied. So what we can say when we say legality, what is the law applied? Which is the law applied? What observance can be made as per law? So that we'll have to see first. So the first is test of legality. The second one is reliability, how far we can rely upon the evidence. How can we test the reliability? We'll have to see how accurate it is. Then we'll have to see how faithfully it is administered. Then from that admissibility, reliability of admitted evidence, we can go to, we can say authenticity. Then validity, we can go to validity, how far it is accurate, as I said, how far it is accurate, how far it can be administered, that is known as validity. So we can test the validity secondly. And thirdly, we can go on to reliability, that is how far it is consistent, whether it remains or it shows the same score throughout the process. And finally, we can go to authenticity and then to truthfulness. Authenticity in the sense that what is the authentic source from which the evidence is given, from which the evidence is collected. If it is not authentic, we can't consider it as proper evidence. Then we can go to truthfulness. It's very difficult to test the veracity, but anyway, we'll go to the standard of truthfulness. All this can be checked. So there is a lot to study about forensic evidence. We are not very much convinced. Most of us are not very much convinced with the science of forensic law. So even silence can be considered at points of discussions. If a person is remaining silent, that can also be taken up as an evidence. So everything, psychological, all aspects can come in. So this can be considered as a part of law, where we now give more importance, because now many convicts can go, they can walk out freely if there is no eyewitness, isn't it? So unless and until we go for this type of evidence, forensic evidence, many of such persons can walk out scot-free. So that is a very important point that we'll have to notice. Then another one is, we know that many innocent people will get punished. If you don't do it fairly, many innocent people will get punished. So such things won't happen. At the same time, criminals should be punished. So in such a way, this has to be streamlined. So whether do we have a law? No, we don't have an appropriate law now. So we'll have to go for a law first. So all this will have to come in our discussion So all these are have to be considered in your discussions. So with these few words, I express all my happiness and wish you all the best and success in your seminar. I thank you all once again for inviting me to participate in this venture. Thank you.
Thank you so much, ma'am, for your valuable words of wisdom. The beginning is the most important part of the work, as once quoted by Plato, who is an Athenian philosopher during the classical period in ancient Greece and the founder of the Platonist school of thought. Now I invite a man who is the epitome of distinct insight and discipline, Dr. Mahadevan Pillai sir, Vice Chancellor, University of Kerala, for delivering the inaugural address. It is an honor and privilege to have such a distinguished personality on this occasion. Sir, please.
Am I audible?
Yes, sir, you're audible.
Most respected Advocate Nagaraj Narayan, Director, Kerala Law Academy and member of Bar Council. The President of the function, Dr. Sindhu Tulasitharan, Head of the Department of Law, University of Kerala. Most respected Dr. Alexander Jacob, IPS, retired GGP and Nodal Officer, National University of Police Sciences and Security Studies, Professor Jiva Nirila, Professor of Faculty of Law, University of Colombo, Dr. Fargav C. Patel, National Senior Assistant Professor from National Forensic Sciences University, Dr. Harindran, the Principal of the Law Academy, Dr. G. Anil Kumar, and Dr. Darshana Saraswati, and other distinguished professors and teachers from Law Academy, and dear students and delegates. It gives me immense pleasure to participate in this international seminar, and which is seminar on credibility of evidences by forensic practices in crime investigation, organized by Kerala Law Academy, Law College, Trivandrum, in association with the Center for Advanced Legal Studies and Research. And the topic selected for this international seminar is of very much importance. Every criminal trial is a voyage of discovery in which truth is the cause. The public interest demands that innocent should be absolved as early as possible with a just, fair, and reasonable procedure. Forensic science is a versatile and enormously powerful tool in the investigation of crimes. It plays a vital role in the criminal justice system by providing precise information through the analysis of physical evidences, the identity of the culprit through personal clues like fingerprints, footprints, blood drops, hair, etc. The criminal justice system in most of the instances put hands on forensic evidences to convict or acquit the accused. The forensic science and its resulting expert testimony, which has got legal validation through Evidence Act 1872 under Section 45, guarantee itself an aura of credibility. There have been many advances in the forensic sciences in the past 50 years, including the development of DNA typing, physical evidence databases, and scientific instruments. A knowledge of forensic tools and services will enable any investigator to recognize and seize on evidences opportunities otherwise unavailable. The picture of physical evidence found at any crime scene only has a face value as a collection of objects to be viewed and considered in their existing connection to the event. Analysis of those same objects using forensic tools can add significant information, making a circumstantial connection between the place and the event and adding new insights. Forensic analysis can make the difference between solving a crime and it becoming a cold case. Forensic science deals with the application of the knowledge and methodology of various disciplines of science to legal matters. It involves the use of multiple disciplines such as physics, chemistry, biology, computer science, and engineering for evidence analysis. For instance, physics is used to understand the pattern of a blood spatter, biology to establish the source of an unidentified suspect, chemistry to determine the composition of the drugs. Thus, the role of forensic science is in criminal justice and the legal system is highly critical, but is often underrated. The primary object of criminal trial is to guarantee due process, and in modern parlance, it means that a trial based on an equally impartial and just investigation on the basis of material which is beforehand disclosed to the accused. Evidence is the primary cream of a criminal trial, and in the case of a forensic evidence, the potentials are to prove whether a crime has been committed or establish key elements of a crime, place the suspect in contact with the victim or with the crime scene, establish identity of the persons associated with a crime, exonerate the innocent, and corroborate a victim's testimony and assist in establishing the facts of what occurred. The duties and responsibilities of a forensic scientist within a criminal investigation are crucial, as they involve meticulously examining the evidence while making sure it cannot be manipulated. A diverse pool of forensic scientists and forensic tools go into the investigation of a criminal act. For instance, forensic pathologists are skilled at determining the cause of a death by performing autopsies. An autopsy helps establish the cause and manner of death through the examination of body fluids and tissues. Forensic scientists analyze physical evidence, that is fingerprints, blood, hair, etc., collected from the incident scene to identify the suspects. Additionally, forensic professionals use image modification tools to search for criminals absconding from the law for a long time. These tools enable them to digitally age a photograph to understand how the individual would look at aging. Forensic evidence is useful in helping solve the most violent, brutal of cases, as well as completely non-violent cases related to crimes such as fraud and hacking. If a decomposing body is found in the woods somewhere, forensic scientists can use DNA, dental records, and other evidence to identify the person, determine the cause of death, and sometimes determine if the body contains material from another person who may have been present at the time of death. Investigators often look for forensic evidences in cases where sexual assault is suspected. In some cases, DNA evidence can prove or disprove the allegations of rape or child molestation. The field of forensics is not only limited to evidence obtained from people's bodies. Ballistics, otherwise known as weapons for testing, can tell investigators a lot about the cases where gunfire was involved. Did a bullet come from a particular gun? Where was the shooter standing? How many shots did they fire? Ballistics can help answer all of these questions. Another area of forensic evidence lies within the circuits of our phones and computers. Those who commit cyber crimes leave behind traces of their activities in databases and documents scattered throughout the digital web. A forensic computer specialist know how to sort through the information to discover the truth. Forensic science is that piece without which the puzzle of a criminal investigation is incomplete. Without the application of forensic science, criminals can never be convicted unless an eyewitness is present. While detectives and law enforcement agencies are involved in the collection of evidences, be it physical or digital, it is forensic science that deals with the analysis of that evidence in order to establish facts admissible in the court of law. Thus, in a world devoid of forensic science, murderers, thieves, drug traffickers, and rapists would be roaming scot-free. With these few words, let me, with all your permission, let me inaugurate this international seminar. Thank you.
Thank you so much, sir, for inaugurating and for delivering your valuable words of wisdom. Knowledge is power. Information is liberating. Education is the premise of progress in every society and in every family. Today, we are blessed with the presence of Dr. Alexander Jacob, sir, IPS, retired Director General of Police, Nodal Officer, National University for Police Sciences and Security Studies. He is the fountain of enlightening thoughts and an idol of intelligence and experience. He has always been a source of inspiration for young aspirants and has completely dedicated himself to his career, which began in the year 1982 in Indian Police Services. He was awarded the President's Medal, Police Medal for meritorious service by the President of India on the Republic Day 2004, and several other awards on marking his dedicated and selfless service to the nation. It's an honor and privilege to have such a distinguished personality onto this occasion. With immense respect and pleasure, I invite Dr. Alexander Jacob, sir, IPS, to give the special address. Sir, please.
Respected Vice Chancellor, respected President of this meeting, all the distinguished faculty, students who are listening to me from different parts of the world. I congratulate the organizers for organizing such a conference on a subject so relevant to the law and order situation of India. Forensic science is known from time immemorial. The first type of forensic science application comes in the Adi Kavya Ramayana. Sita Devi was kidnapped and Lord Rama is searching for her. And if you look at the way the investigation is going on, they come on the way, find the ornaments of Sita Devi on the ground. Then Rama proceeds and he finds the bird who is attacked by Ravana, and he asked the bird, what is happening? And the bird told that I attacked Ravana and Ravana hit me and I got injured, I am on the ground. Then slowly this investigation goes on. Ultimately, Rama finds out Sita Devi is kidnapped to Lanka. And then the war is on and Sita Devi is liberated. Now, if you listen to it, the first lessons of forensic science is applied in that. When you come to Mahabharata, we again find forensic science and forensic medicine. Bhima is found unconscious. How he has become unconscious? They ultimately find out there is a poison in his body. And that poison is from Kalagudam. And what is the antidote? So they find out the antidote and give it and revive Bhimasena back to health. So how an investigation, forensic science investigation on a crime is applied. Reculum is burned down to kill all the Pandavas. And then they find out that the Pandavas have escaped. And Bhima comes to the river to pay the final prayers for the Pandavas. Vidura comes and tells Bhishma, look, you cannot do this kind of prayer to people who are living. Bhishma tells, are they alive? Vidura says they are alive. I found out that they have escaped and they are at a particular place. So the details of that tracing of the Pandavas, you apply forensic science, meticulous application of forensic science. When we come to Bhagavatam, again we have tremendous amount of forensic science applied. Lord Krishna is accused of a false charge of killing a person and taking a diamond. Now Lord Krishna have to prove that he is innocent. So he goes on a forensic science, this kind of investigation, and ultimately find out who took the diamond and how he was killed. And then he proved his innocence. Now, if you look to our Puranas, we can find large number of this kind of forensic science and forensic medicine applications. But the detailed investigation we find in a 4th century drama. The name of the drama is called Brichakadiyam. And it was written by a great dramatist called Shudragan. He lived in Orissa, according to the present day Orissa. Now, Vasavata is killed. So, who is the murderer? It has to be proved. A false charge was foisted on the lover of the woman. And the trial is going on in a court of law. And the investigation is checked, rechecked, examined. But ultimately, it was not proved by forensic science. That is the fun of that drama. The dead woman's soul came back and told the court, look, I was murdered by so-and-so like this. Now, 1600 years back, a full investigation was not possible. So miracle was given the chance of proving the case. Now, the lessons of forensic science is very well clear in the act after act in the Brichakadiyam, the famous Sanskrit drama. What I am telling is that don't think that forensic science is a modern science. It has become modern with a lot of tools in our hands now, but it has started thousands of years back. And we go into the historical lessons from forensic science. It gives valuable insights into the way the science are developed. People who do want to do research in this area may proceed on this area. Large number of PhD theses are possible in the history of forensic science. But today, what is the problem? The main problem is application of forensic science is given to a very, very few number of cases. You take Kerala. Kerala have 12,75,000 cases recorded last year. The forensic science laboratory in Kerala put together can do research or investigation around 6,000 cases. The chemical laboratory in Trivandrum they usually investigate up to 9,500 cases. So put together, what is the application of forensic science in the investigation of cases in Kerala, the most advanced state, the state in which have Kerala police listed as #1 in India for the last 18-20 years. We are #1 in India. In the #1 state for investigation, the application of forensic science is only for around 15,000 cases out of 12,75,000 cases. So the amount of forensic science applied in investigation is hardly around 1% or 1.5%. The 98.5% of the cases, no application of forensic science. This is the biggest danger we are facing now. So if you don't apply forensic science, then how cases are being cleared? Most of the time, third degree is used. You and me will shout on the street, no, third degree is permissible. Then what is the way to prove a case? I was taking a class for sub-inspectors. One sub-inspector asked me, sir, you tell us that no third degrees can be used in investigation. So what are the 4 degrees applicable? I said, have you not read Samam, Danam, Hedyam, Dannam? These are the 4 techniques, 4 degrees. The sub-inspector simply asked me a question. Sir, can you apply the first 2 for investigation, Samam and Danam? There is a possibility for a sub-inspector to have a Samam. There is a possibility of sub-inspector with a poor salary to give Danam. So what is the first thing possible for us? Hedyam, third degree. That's what we are doing. So if 1.5% cases only have forensic science applied, then 98.5% of the cases is being investigated using third degree and other methods. This is the danger of criminal investigation in India. Mind you, Kerala have the largest number of these facilities available. Because of which, what happens? The net result. In IPC offenses, conviction rate in India is less than 30%, 30%. In many states like UP, Bihar, Madhya Pradesh, conviction rate is 15%, 18%. The state with the largest amount of conviction is in Kerala. Kerala have achieved 71% in conviction rate in Indian Penal Code offences. We are ahead of even Scotland Yard, the most reputed police force. Their conviction rate is 44%. We achieved 71%, well and good. But total India, if it is less than 30%, that is a poor state of investigation in India. So if India, criminal investigation have to be saved, if people have to get justice, if victims have to get justice, then more number of forensic science applications has to be there. Forensic laboratories have to expand. New facilities have to be added. And the number of laboratories have to increase. And at least 50% of the cases should have forensic science application. So this is the second aspect we should take care when we discuss such a theme for our international seminar. The third thing is application or taking evidence in a criminal case where forensic science is applied. For example, we will take murder case. When there is a murder case, we usually ask 6 questions and find out the answer. Police will investigate the case and give it to the prosecutor. Prosecutor try to take evidence in a court of law and get the accused convicted. But then there is a defending lawyer. He will come to save his client. And then what happens? Each of these evidence will be torn to the shreds by the advocate. He is paid for that. And even if 1,000 criminals escape, one innocent man should not be punished. That's Indian law. So when this thing is done, the 6 questions are asked. First question is, who was killed? Second question is, where was he killed? Third question is, when was he killed? Fourth question is, how was he killed? Fifth question is, why was he killed? And the sixth question is, who killed him? If you cannot answer the first 5 questions with forensic science, that case will be just going to the shreds. The accused will escape. He will laugh at the police and the victim and go away coolly from the court of law. In each of these cases, forensic science is a tool. We'll take one case, most famous case in the first question. Who was killed? With the forensic science, you have to prove who was the person who was murdered. In Palakkad, there is a famous case, Chandran murder case. A person called Chandran and Madhavan fought in a toy shop. Madhavan said, by tomorrow morning, before the sun rises in the east, you will be killed, Mr. Chandran. Chandran was afraid. But next day morning, a dead body was found on the road. Same Kylie, same height, same color. Even a black mole on the cheek was visible, but the face was being burned using some kerosene or something. So facial identification is not possible. But same color, same black mole, and same height, same Kylie used, same lungi. Madhavan was arrested because there were 5 witnesses that Madhavan threatened Chandran the day before, and morning body was found. Madhavan was taken to the court, and Honorable Justice U.L. Putt was the district and session judge of Palakkad. And he gave a judgment. He has to be adored for such a judgment. He says, where was he killed? When was he killed? How was he killed? Etc. All the things I accept. But the first question, the prosecution has failed to prove that the dead person is Chandran. The forensic science evidence is not enough for me to believe that Chandran is killed. If Chandran is killed, Madhavan is the accused. He has to be hanged. But the prosecution has failed to prove that Chandran was killed. Madhavan was let off. After 4 or 5 months, somebody from Palakkad went to Coimbatore. They found Chandran standing there. They said, Chandran, you are not dead. He said, no, Madhavan has threatened me to kill me, so I ran away from the place. So they brought Chandran back to Palakkad before the police. Police found the dead man alive. With that single judgment, Justice U.L. Putt was raised as a High Court judge. Later he retired as the Assam Chief Justice. Great man. I touch his feet every time I meet him. Great man. No judge at that time could have delivered such a judgment. His knowledge of forensic science is such that justice found out that that person is not Chandran. This is a lesson for police. This is a lesson for forensic science and forensic medicine. If forensic science is not capable of raising enough doubt to identify the dead person, then justice will be miscarried. Some innocent man will be hanged or put to prison. Prime Minister Indira Gandhi was killed. Dhyan Singh was shot dead. Satun Singh and Kahar Singh were hanged. 3 years later, police and the judge who convicted him told, we are wrong. Kahar Singh was innocent. When Beyan Singh or Satun Singh was planning the assassination, during that time, Kahar Singh used to visit that house. He was a friend of Satun Singh. He used to come and take a cup of tea and used to go away. But Satun Singh and Beyan Singh has never delivered, never told this fellow that we are planning an assassination of Indira Gandhi. Kahar Singh was hanged. By the forensic science and investigation agency didn't link Kahar Singh properly with evidence to the case. Because of the publicity, he was hanged. What use? 3 years later, the judge says, I'm sorry, he was innocent. So, a collection of forensic science evidence is very, very important. The second question is, where was he killed? If the place of death is not identified properly, then the accused can have alibi. If the murder happened there, he will prove that I was 200 kilometers away at that time. End of the case. The real accused escapes. So a man may be killed 500 kilometers away. A lady was killed in Bombay. Her body was put in a box, and box came the Ernakulam railway station, where it was opened. Unknown body, no identification, just a box. From where intelligent Kerala police traced that case back with the 2 signals on her body. They slowly identified that she is a Hindu woman. Second, they identified from a Pachagutta symbol, they identified probably her name is this. And then they traced back. Ultimately, they went to Bombay and arrested the accused. They were convicted in that case. So this is where he was killed. You have to identify. When he was killed, if the time of death is not properly finalized, again alibi comes. The man was murdered at December 23rd, midnight, 11 o'clock. If that is your identification, and if the accused says, no, I was at that time at Ernakulam, end of the case. So, when was actually the murder? You have to prove it through forensic science. Then only the accused can be brought to book. And the fourth one, how was he killed? What was the method? One lady was killed with 8 stab injuries. 8 stab injuries. She died because of a stab injury in which the knife entered through the ribs, broke her heart, and she died. But when the inquest was done, when the injuries were marked, this particular injury, the breast had come down and the wound just merged back. So the inquest, signed by the Panchayat president, signed by the doctor, police officer, everybody, 7 injuries are marked. This particular injury is not marked because the wound was almost merged back. Case came to the court of law. The accused escaped. If you don't identify the wound, if you don't identify the cause of death correctly, it helps the accused. So forensic science, forensic medicine put together, it's a vital tool. You have to correctly prove how the person was murdered. If that how is not proved correctly, then the case can go without any conviction. Says, why was he killed? Mens rea. Was it for plunder? Was it for rape? Was it for killing the person so that his property will be inherited by the accused? So this is very, very important. Which perhaps a death note will be proof. Sometimes a document made 6 days back will be proof. Some document somewhere. You have to correctly identify why was he killed. You cannot just say a man was walking the road, so he got into the house and killed that fellow. No theft, nothing. Case will go, nothing will happen. So how, why, what is the reason? If you correctly identify all the 5 questions, then the 6th question is easy. Who killed him? In each of the steps in investigation story, the correct investigation is possible only with the forensic science. DSP Shaji killed his nephew. He suspected his nephew have some connection with his wife. He murdered him, cut him to 5 pieces, and then buried it at 5 different places. But police officers, forensic scientists got together. Within 48 hours, all the 5 parts of the body buried it, collected together, made it as a body in a coffin, and then buried. And the DYSP, who was in charge of the police department, who did the murder, was convicted. He landed up. There is one film which did a lot of damage. Famous film, Drishyam. Mohanlal is acting very well. Film is very good. I have no problem with that. But the theme of the film is murdering a person and concealing the body in such a way that the case could not be detected. What's the theme of that film? Failure of forensic science and forensic medicine and the police in detecting that dead body. You enjoy the film. You appreciate Mohanlal for the great act. But police officers like me and the forensic scientists who are listening and the advocates who are listening to this class, who may become a judge tomorrow, for you and me, the class is different. How forensic science and forensic medicine can grow to such a way that the dead body can be traced and the accused brought to book. That is the way we have to appreciate that film. So this is the way forensic science has to develop. Molestation happens, rape happens. Luckily for us, we have the DNA molecule coming into our help now. And if you do proper investigation with forensic medicine and forensic science, you will be able to detect that case properly. Now, forensic archaeology is a wonderful tool coming up now. The whole of Indian history was rewritten. We learned about Indus Valley civilization and we said this, that, etc., etc. The Europeans, they wanted to make the Aryans and Dravidians fight. So they invented the Indus Valley civilization, invented within inverted commas, discovered in inverted commas, and said Indus Valley civilization belonged to the Dravidians and the North Indians are different from the Dravidians and all kinds of things. We have no method to disprove it. Their language could not be deciphered. Who are they? Nobody knows. But now forensic archaeology came up. We developed the art of extracting DNA samples from bones of 36 people, skeletons of 36 people who are 4,000 years, 4,500 years old. From them, DNA was extracted. Now, from that dead body, that skeletons, we proved that the people are a cross of Iranian farmers and the hunter-gatherers put together. The entire Indian history changed. Whole British returns history changed. So that is forensic archaeology. Even if the dead body is thousands of years old, you can find out a case. Tutankhamun's skeleton was uncovered 1922. For 100 years, we speculated, who is this Tutankhamun? What is happening? We found out that he is Akhenaton, the fellow who brought the first monotheism. There is only one God theory, 1360 BC. He had only 6 daughters. So the elder son-in-law was Tut. He is called Tutankhamun. He was actually Tutankhaten. But now he converted his name to Tutankhamun. How he got killed? A murder which happened 3,200 years ago. forensic science went into business. They found out that one of his legs were broken in an accident, and probably he was killed when he was 22 years old, very young man. And truth took over power, and which led to the invasion of Egypt by Hittites from the north, and all those theories. So a murder case is investigated and proved 3,200 years ago because of forensic archaeology. This is the wonder of the science, forensic science. Now, when we go into this forensic science, both existing cases or cases which are hundreds of years old can very well be proved if a slight amount of forensic DNA can be extracted out of the body. We found out that many bodies recovered from the ice of Europe were real murders. They were murdered and given to the gods for satiating the gods. So forensic archaeology, investigating cases thousands of years old, is a joke now. That is the advancement of forensic science. I will stop with telling one more item. That is the challenge of modern forensic science. When Evidence Act was there was no telephone. There was no recording system. There was no mobile phone. There was no computer. There was no fake notes. There was no cryptocurrency. So Sir James Stephen, when he drafted the Evidence of 1870, wonderful act, most perfect act of Indian history. After 150 years, hardly only 2 amendments could be possible in that Evidence Act. That is the perfect nature of an act. He envied the man, Sir James Stephen. But when he made an Evidence Act, which is applicable in our courts now, new crimes have come. Terrorism have come. A man sits in New York, operates. Osama bin Laden sits somewhere in Afghanistan. He arranges money, send 20 people to America, board a flight, use of that flight to hit the World Trade Center, killing 3,000 people. From World Trade Center, we have to trace back that investigation. There's somebody who is staying in Afghanistan, thousands of kilometers away, across the ocean. To reach that criminal, forensic science requires full new methods and innovations. One fellow, Mario Soros, sat in New York, started operating his computer on the value of ringgit, the currency of Malaysia. 3 hours, Mario Soros destroyed 70% of the value of ringgit, a currency which was built up in 150 years. 70% of its value destroyed in 3 hours. This is the crime of 21st century. This happened 8 years back. Now, with the forensic science, you have to go and get this criminal who is sitting in New York and destroying a country and its currency. Because Indian rupee is not fully convertible, somebody cannot operate on Indian rupee. But a lot of currencies are fully convertible. You can damage the system. Using a mobile phone, you can create a bank fraud. 2 BTech students in America operate in such a way that if anybody transfers $10,000 from one account to another account, just 1 cent, 1% of $1 will be transferred to his account. In America, millions and trillions of rupees hands over charge, from which just 1% of $1 get transferred to his account. He started getting millions of rupees. They found out a college student is using this kind of tremendous money. They arrested him and started checking what is happening. Then they found out what it is. This is the modern crime. America appointed that fellow as the anti-operator for the Reserve Bank of America, Central Bank of America, to prevent such things. US made the man because he could only do this, so he could prevent others from doing it. In India, he would have been beaten up and put in a central jail. In America, they respected his merit. Forensic science had to find out such a criminal. Mobile phone crime, cryptocurrency crime, cheating of the worst order, just creating a site, telling some people, the Reserve Bank is contacting you, you have to do this, you give this OTP number so that the operation can be completed. Innocent people, including a DIG in Karnataka, gave the OTP number. He lost 1.5 lakh rupees. A college professor in Trivandrum lost 35,000 rupees. She gave her number of the credit card and the OTP. 35,000 rupees lost by the time she contacted me. So I stopped it before further money was lost. College professor, DIG of the police, cheated by some intelligent person. So this kind of crime happens. And modern forensic science and the Evidence Act have to gear up to modern crimes with equipments which have been invented hardly 30 years back. You have to operate the Evidence Act 1872 to get a crime using an instrument which was invented only 30 years, put him before the law and get him convicted. So this is a challenge of law. This is a challenge of forensic science. And this is a challenge for the police. I congratulate for organizing such a seminar. And I wish at the end of this seminar, vital details and very good innovative things will be found out or decided upon as a result of this seminar. So that modern forensic science, police, and the lawyers, many of who are listening to me may be sitting in as certain judge or high court judges 20 or 30 years later. You will be able to tackle these criminals using the advanced knowledge which will come out of this seminar. Best luck to all of you. Thank you.
Thank you so much, sir, for your inspiring and yet knowledgeable words, which were truly special. A good teacher can inspire hope, ignite the imagination, and instill a love for learning. This saying is true in all senses. Now I invite Professor Jivanarela Ma'am, Faculty of Law, Department of Public and International Law, University of Colombo, for the keynote address. Ma'am, please.
Thank you very much. Very good morning to you all, though it is about to 12 noon today. The first, I would like to extend my sincere appreciation, the gratitude to the Kerala Law Academy, Law College, to inviting me for to deliver the keynote speech. Actually, when I was invited, simply the organizers asked that whether I can deliver the speech at the inaugural session. So this Kerala Law Academy is not a strange place to me. I think that I have delivered the speeches at several international conferences. Whenever you organize a conference, I think, you do not forget to invite me. So therefore, whenever you invite me, how much that my time schedule is busy, doing, very good the research according to the time which is permitted to me, as well as my ability. I try to do, some of the dissemination of the knowledge with my loving neighbor country, India, and my loving the academic institution, that is the Kerala Law Academy. So then all the dignitaries, the head table and the head table, and all the participants, I saw that there may be more than 230 odd participation are there. It tells us how this the conference is important, rather the seminar is important. It is not only for your country, it is equally applicable to all over the jurisdictions, because we are, though we say that the modern the technology, or rather the forensic the science and for the evidence based on forensic science are really necessary, important, but when it is the application, I think you all will agree that there are lots of the issues in relating to the application. So having said that, my dear friends, now you have selected the theme. It's very currently important. That is the credibility of evidence by forensic practices in criminal crime investigation. So there are, I think that many of you might have focused on when you submitted the research, the papers about the evidence part. That is, the law, which is related to the expert evidence. And if there is any law, we must consider that relating to the forensic evidence. Forensic evidence, I mean, in whether we have any specific laws in our laws of evidence to recognize and to minimize the issues pertaining to the forensic evidence. So the next one is crime investigation. So when it comes to the investigation, whether it is relating to taking the forensic, the related information, finally it is fact, and when it comes to the court procedure, that is, we are saying that the evidence. So then the investigation. I think that India, which is similar to Sri Lanka, we have the law for criminal procedure. So then we have to confine all whatever the test, all whatever our investigation, what we are doing to collect the information, rather the facts, that should be confined to the procedure. Therefore, it is very much important, the criminal procedure. In Sri Lanka, we have the criminal procedure code, that is number 15 of 2019, the 79, which is a little bit the archives law to me, in order to, the revamp, to the revisited, in order to properly to be included this particular, the modern, the type of evidence. Why I say modern, it is because of that, using the modern, the science, the scientific tools. So when it comes to the third aspect is the forensic, the practices. So there it is fully talk about the forensic science and related the practices. I'm not that much experience and expertise to talk about that, but being as a lawyer and a law teacher who is engaging in especially the criminal justice perspective, so I try my best to talk some of the new technologies that we can think of, that when it is applied into our law, how we can consider the new type of developments. So my speech actually, that based on the main aspects, I first look at that, some of the tools, the modern technologies used in relation to prove the criminal matters. Then thereafter, I engaged in that some of the issues that in Sri Lanka, we come across. Sometimes we are far behind than India when it comes to the technology and science, as well as the judicial, the activism, that those three perspectives, maybe Sri Lanka is far behind that, but it is a good opportunity for all the students who are engaged in this, the different, this aspect. You can have some sort of collaborative research work, Sri Lanka and India, to see that what kind of development that we can later we can introduce. So, and thirdly, found out the issues, then I have some sort of suggestions for how we can overcome those, some of the activities. So far I have done few researches. The very popular one was the medical legal evidence. I discussed that a lot of issues relating to the law of evidence, as well as the criminal procedure part in Sri Lanka. Now, my dear friends, I think most of our, today's the participants are criminal lawyers, those who are really would like to engage in more and more criminal the cases, being as lawyers, the judges, as well as the previous speaker, Honorable Dr. Alexander Jacob. He came to all the practical aspect. So what is behind that? Why, how, and why is the forensic, evidence, including the forensic science, why it is important. So you all are aware, presumption of innocence is well-established fundamental right guaranteed in any constitution. It is to Sri Lanka, India, wherever the constitution, it is one of the key aspects that everybody considered. So that is because of, to my understanding, to my reading, that is the traditional view of the interpretation of crime and the adversarial system of judicial trial that the criminal justice process is adopted. Therefore, it is very important to prove criminal matter beyond reasonable doubt. Hence, the evidence submitted in a criminal trial is utmost important for both parties, the prosecution as well as the defense. Why? When it comes to the victim side, it is to the justice of that person. Why? Because by committing a crime, that person's rights have been violated. So for the defense party, it is important why any innocent person should not be charged. Therefore, the evidence that are submitted to prove a case or to disprove a case, finally to end up with the justice, it is very much important. So that is where we have the forensic evidences. So then, when it comes to an evidence, so to me, the best evidence should be selected to, win the case. Win the case means finally the justice. So earlier, when you go through all the rules of evidence, you can see that the best rule of evidence. So here, though it was, confined only to the documentary evidence, I have a little bit of a different reading on that. The best evidence means what is the most suitable, the strongest evidence that the crime can be proven. So therefore, it should not be limited only to the documentary evidence. Therefore, the forensic evidence play a vital role in a criminal the trial, as the earlier speaker, Honorable Dr. Alexander said. So the accuracy, the reliability, and the credibility, as one of the previous madams pointed out, of an evidence in a criminal matter is highly important to provide the justice for the both parties, because the person who is engaged in doing a lot of research, don't know whether a lot of, but research in the criminal justice system. So I think that the justice means justice for the both parties. Both parties. Otherwise, violating one party's rights is not the real justice. The general public, we really expect from the justice system. Therefore, my dear friends, the role of forensic science in criminal investigation and the impact of forensic science in the criminal justice prosecution is very much important. Therefore, to complete my today's speech, let me to very simply that though it is the previous speakers talk about the history and the interpretation of the forensic science and the evidence, let me also to talk about in a modern way. So therefore, I'm not going to talk about the history of the forensic science, but let me to say that, simply what is forensic science? Because, to talk about forensic, the evidence, we should know that, first of all, what is the forensic science? Then the forensic science, it is also known as the criminalistics, is the application of science, maybe the traditional science, the modern science, whatever it is, the science, that means following the scientific tools and the methods to find out the results to criminal and the civil. Mainly, I think that, the focus of today's seminar is also on the criminal side. And during criminal investigation, as governed by the legal standards of admissible evidence and the criminal procedure. Thereby, forensic evidence is an evidence obtained by using any of scientific methods called, such as ballistics, blood test, DNA, cyber forensics, so on and so forth, the test that we are using, and the use to, prove the case at the courthouse. Therefore, as everybody very correctly focused on and said, the forensic evidence often helps to establish the guilty or the innocence of possible the suspects. So then the forensic, when it comes to forensic evidence, it has the forensic science part. They are all the forensic scientists, their role and their the activities, their technologies, all these things are very much important. The other side is when the law side, that is the legal side, that is the evidence law as well as the procedural law. So the forensic scientists actually, they are the people with the police, right? Collect the evidence and they preserve the evidence and finally analyze the evidence and during the course of the investigation. So while some forensic scientists actually travel to the scene of the crime to collect the evidence themselves, others occupy in the laboratory role, performing analysis on objects brought to them by other individuals. So I say these things, then, when it comes to the application, these are some of the areas that we have to look into, when we consider the reliability, the credibility of this type of evidence, whether it is, very important one. If this evidence is not a reliable one and it is not a credible one, so then there is a question arises whether we can convict a person based on that. So then in addition to this laboratory work, the forensic scientists testify and expert witnesses in both criminal and civil cases also, and can work either prosecution or with the defense. So as I said, when it comes to this, the credibility of forensic evidence, right, as I said, that it depends on the reliability of the techniques or the methods used in relation to collection, preservation, packaging, transportation, and testing physical evidence left in the crime scene, as well as it is very much important when it comes to reporting. Because how much the test is accurate, when it is, wrongly reporting, if there is an issue relating to the report, so then there is another, it's a question relating to it is the credibility. I hope that many of the papers you have considered, especially your research in relation to maybe the collection, maybe the preservation, maybe that transportation and sending from the test to the courthouse, and then vice versa from the crime scene to the place which is doing the test, and from that into the courthouse, as well as the reporting. So let me to briefly, say that, some of the technologies previously, traditionally in Sri Lanka, maybe common to the other countries as well, which is, using as the methods of the scientific test. They are chromatography, then the spectroscopy, hair and fiber analysis, serology, that means it's a very the famous one, that is DNA examination, and pathology, again a very the common one, and anthropology, long time back, still it is there, and then the toxicology, structural engineering, and examination questionable of the documents. So, my dear friends, so these are the traditional technologies using to, these evidence. So when it comes to this, the traditional or that, the new technologies that we are using, as Dr. Alexander tried to point it out. So that is to prove, I will take that, the philosophical point of view, that is to prove the actus reus and the mens rea. He came with 5 main questions. Those questions are related to actus reus and the mens rea. So taking that, these are the modern, the forensic, the evidence. One side, we are trying to prove the actus reus of the particular, one of the elements of the crime. So it may be a murder, it may be a rape, it may be a robbery, it may be a new crime, money laundering, it may be cryptocurrency crime, whatever it is, the actus reus part, and the other one is the fault elements part, that is the mens rea. So when it comes to mens rea, right, not only to prove the intention, whatever that, the different status of guilty mind, it really, this modern, the forensic evidence, it really helps that to find out the motivation as well. So therefore, I would like to just to simply mention that what are some of the new technologies here in the different, the so-called the developed countries. I mean, maybe India also utilize under forensic science. So they are DNA phenotyping, right? That is when the DNA, DNA are gathered from a crime scene that can be matched to a suspect by comparing samples. So then why I stress that, because the comparison there may be some issue arises in relation to this comparison. So however, then DNA can be used to determine what the suspect is evidence were used very recently. So then it was recently in this back 1995 and 1996. So till then we were not that much familiar with the DNA evidence as well. So then as well as when it comes to the modern technology under the using the computer, the related the technology. So until the very recent past, Sri Lanka did not permit to admit the computer generated evidence. So however, after the new amendment was introduced, now it is permissible. The classic example is the best, the known case is, I think you also might have known that, Attorney General versus Benwell. So it is said that the computer generated the evidence cannot be admitted, or it is not admissible to prove a case. However, after that, we had to amend the existing law in Sri Lanka to come with the new amendment in order to admit the particular case, the type of evidence. So then there is another new technology which is used by biosensors of fingerprint analysis. Earlier, again, the comparison, now how today we are having the biosensors of fingerprint analysis. There is another one that is the geolocating a suspect or victim using stable isotopes of the water. There, what does it mean? Right, isotopes vary from atom, and we call it the atom, and can have a unique signature for each and the different situation. So recent forensic actually developments have found that the scientists can determine where the sample could have originated by isolating the isotopes in a water sample found on a suspect or the victim. That is very much important when it comes to especially the murder cases. So there are a lot of the examples then you can find out from the other countries, but very difficult to find out in Sri Lanka. So it is the using this particular new the tool, that the detection can do that to find out who the real suspect is, or who the real victim is among many the people. So there is another new technology called forensic pinology. The forensic pinology is a relatively a new area of forensic scientists. For the forensic scientists, if there are forensic scientists, I mean, they will come with a lot of ideas on that. So it is relatively new. So there is a study of pollen, right, grains and the seeds that can be used in forensics to identify subjects' location. So that is also very much important when it comes to the previous, the speaker said that, you know, where the particular crime has taken place. So then the pollen, or that, you know, these the grains and whatever that the seeds and all these things are the use, it will deposit on the skin and the clothes, largely the undetected. So therefore scientists have not to some extent, you know, this is the particular tool is utilized in order to find out the person who has committed the offense, and where the place that has been taken place, as well as the time of the commission of the offense. However, there are some the issues pertaining to when it comes to the application. So then there is another new tool, right, you can consider, that is the social network forensics. So as you are aware, more than the billions of people in this world, they use the social networks. So then when it comes to social media first emerged, right, the investigators and the forensic scientists, they did not know actually have as much data for this, you know, the in relation to this particular the incidents. So however, today the social media data for particular subjects can be find it out in relation to this forensic, the social network forensics. However, as I said, again, there are some issues pertaining when it comes to the implementation. The 3D technology determine the physical, the fits. There is another, the new, the scientific methodology used to, I mean, using the medical science, or that, you know, the medical, the forensics in the criminal cases. So then the drone forensics, then the alternative light, the photography, and the high-speed ballistics photography, video spectral, the comparators, digital surveillance of Xboxes, we call that XFT devices. I mean, today the police officers and the scientists who are in the digital forensics side, they, I mean, know more than me, because I'm coming from the law field, and how that can be utilized in the crime detection. So then the other one is the 3D forensic physical reconstructions, then the magnetic endographic, and the automated fingerprint, the identifications, forensic carbon-14 dating, that is a little bit of an older one. So then the software for forensic, the accountants, I mean, the new softwares to find that out, I mean, to detect some of the crimes or whatever the activities committed in the digital world. So these are few the tools and the mechanisms, the new technologies using in the field of forensic science. Now, that is to find out, as the previous speaker said, that whether the particular person has done that, that is, you know, and whether this particular the transaction or the issue, right, is related to get the final outcome or the results that is, you know, prohibited by any of the penal statute. Therefore, whatever these, you know, things we are used, what are the issues pertaining to, this is the second part, very quickly I do that and I will conclude my speech. So what are the issues related to when it comes to the forensic, the medical evidence? When I went through all the different the technologies that we use under the forensic medicine or other forensic science in order to, to do the detection, and with that, compare that with our evidence law, that is the evidence ordinance in Sri Lanka, so that the reliable and the invalid forensic science, that discipline, it is one of the issues. I think that, you have to do some of the studies to find out that how the reliability and how that the validity of this particular, the evidence that we are submitting to the particular criminal case. When I did some sort of, the readings, I found that some of the studies have demonstrated that some forensic, the methods using criminal investigation cannot actually consistently produce any accurate results. I think that was touched by the madam at the very first time he at her speech. So therefore, the testimony, the expert testimony may contribute to the admission or that, erroneous of misleading the evidence. Some forensic techniques, particularly those that deal with comparing patterns of features. For an example, the footsteps, then the bite marks, the fiber and hair, so on and so forth. So then have not been subjected to scientific evaluation and to find out its accuracy. I think that in this the discussions and the deliberation, I think some of you might have focused your research in order to consider this issue as well as to come with the innovation to overcome this particular issue. That means the reliability and the validity. There is a question in relation to this forensic evidence. So then we have to come with some of the new research work to find it out in what ways the mechanism, the methods that we can utilize in order to minimize that. Because otherwise there's no point that how much this is important if it is not reliable and it is not, they cannot find the validate. So then it is no point to say that it is very important, the evidence to prove or disapprove the case. The second issue that I find that is the sufficient validation of a method. Although some of the forensic disciplines in use may capable consistently producing accurate results, but there are, has not been the sufficient research to establish its validity. Accuracy of method should be established using large, well-designed studies. That is what is more required. So without these studies, the result of an analysis cannot be interpreted. So analysis of say that, the footprints or the shoe prints as a basic of identifying the unique source of a print is an example of a method that has not been so far scientifically validated, especially when you consider Sri Lankan situation. The third one is confusing the testimony. So sometimes the forensic testimony overstates or exaggerates the significance of similarities between evidence from the crime scene and evidence from an individual, or oversimplifies the data. One example, including testimony that suggested collection of features is unique or overstates how rare or unusual it would be to see these features, implying that it is quite likely that the suspect is the source of the evidence, and testimony that doesn't convey all the possible conclusion as can raise with masking on serology testing. Sometimes forensic testimony understands, downplays or omits the significance of an analysis that they establish that an individual should be excluded as a possible suspect. One example is that the testimony that an analysis is inconclusive when in fact the analysis excluded the suspect. Also, sometimes forensic testimony fails to include information on the limitations of the method used in the analysis, such as the method's error rates and the situation in which the methods has not been shown be valid. It's also when it comes to confusion testimony, like everyone, you and I, forensic practitioners also can, do some mistakes, including mixing up samples or the contamination of the specimens. Then these can finally occur in any type of science and the laboratory testing. I think that you all agree to this point, even in well-developed and well-validated fields. Therefore, we have to come with that, some kind of mechanism how to minimize that type of errors. There may be the protocols or maybe some sort of guidelines should be included into our procedural rules to, overcome this issue. So then the other one is misleading the testimony, though we sometimes disagree with that. This also can be happen. In some cases, forensic analysts may change the test results. That can be happen. Maybe sometimes, just I don't say that misusing, but that may be also happen, right? This is also possible. Therefore, you have to do some sort of research, taking examples that where that, the reporting and the testing can be, have, some sort of the irregularities involving. They are how we can overcome that. Therefore, when it comes to this, the specific, the testing, when you do that, we have to have some sort of policy and the guidelines should be included. That should be come from the rules point of view. That means from the legal perspective or the legal point of view in order to minimize that. So then the fifth one is lack of the trained scientists who have the legal knowledge. I think it is not necessary to explain that. There, what would happen is most of the important things are, not revealed, but however, because of the less knowledge of these scientists, they are in the legal knowledge. So that therefore, always the scientists should have some sort of legal knowledge. So then the lawyers, the judges also have some sort of the scientific knowledge. So where we can fill that gap, having this type of seminars and having, include some of the programs, the study programs into your, the degree programs in the medical field, in the science field, as well as the law field. I hope that, we are having that, especially the police science, the degree programs that you included in the different other crime investigation methods. So then the issues pertaining to procedural laws and mechanism. So I think that is, that when it comes to the procedural law, I think that you also have the procedure, the Procedure Act you have. Sri Lanka, Sri Lanka is a blueprint of the Indian, the procedural code. So when it comes to the procedure, right, to collect and to preserve and to send it to the testing, when the test is taken place, and when it comes to the courthouse. So then there are so many, the lapses are there. So then there may be, therefore the law should look at that to have some sort of the mechanism in order to minimize those, the lapses. So then the one I mentioned would be mentioned here. Very quickly, give me 5 minutes to conclude the presentation. The contamination and the loss of the continuity. So then if take one example, the rape case, that when the prosecutors come to the police to give the first information, then thereafter how long it is taken to to do the test and all. So there anything could be happen. So one example is more than enough. So then the next one is under the issues in the procedural laws and the mechanism, the ethical dilemmas in the forensic techniques that we use. Right? Among them, I would like to draw your attention, the competency and the delegation, the delegating the work to the others. I think that this is commonly happen. right? And avoiding the harm, especially the mental trauma when the person who is, testing, who is under the test of the person who is conducting the test. So the other one is the informed of the contest, the consent. So these are some of the issues pertaining to procedural laws and the mechanisms. So if you say that forensic is very much important one. I mean, to prove the actus reus as meant as the mens rea, or else the vice versa. Nice that I have some, came with some of the suggestions. Maybe it's very common. That is, the solutions can be recommended here to conclude the presentation, right, through the scientific perspective as well as the legal perspective. So then the first one is, it is important to scientific evaluation be conducted on an ongoing basis to assess the foundational validity of current and newly developed forensic feature comparison technologies. That is one of the important one. You can do some of the research on that. So then the second one, there should be an organization in developing and promoting standards and guidelines to improve best practices in the forensic science community. So then that is another way, part that you can do some of the research. The third one, the research and development strategy should be developed to conduct required studies, improve current forensic methods, and develop innovative new methods. It is another aspect that we can do that, to make some solution to the things that I have identified or just posed to you to consider as some of the demerits of this, forensic, the technological, the forensic medical evidence. So the other one, the next one is, it should be ensured that the expert testimony in court about forensic feature comparison methods meets the standards for the scientific validity. This is of course related to the previous one which I said. When deciding the admissibility of the expert testimony, judges should take into account of appropriate criteria for assessing scientific validity, including foundational validity and validity as applied. So the judges should ensure that when experts are testifying about the foundationally valid method, the stated accuracy of the method is in line with what empirical evidence supports. So lastly, the best practice manual should be developed to provide the guidance to judges concerning the admissibility of expert testimony based on the forensic medicine. Actually, some of the research are now doing. I'm also involving to come with what type of best practice manual can be developed in relation to, consider the admissibility of expert testimony, because Sri Lanka, we have only one particular section, that is section 45 of the evidence ordinance in relation to expert evidence. So, this is what I want to discuss with you today. I think that, many of the deliberations that you have in today, many researchers come from the scientific the side, as the medical science side, or the forensic the science side, as well as the legal side. You, the lawyers, the judges, all the students and the researchers, you will discuss many of the things that I have discussed with you generally. I discuss with you, and you will pay your specific attention on the different parts to come with the novel ideas, the novel thoughts, the new laws, to minimize these things, to strengthen the criminal law in not only in your country, which can be utilized even the other countries where the jurisdictions that we have all this type of problems in relation to forensic medical science. Thank you very much for listening to me. And I want to thank all of you, especially the organizing committee giving me this opportunity to share some of the thoughts relating to the credibility of the forensic evidence and the best forensic practices. Focus on the international seminar. Thank you very much.
Thank you so much, ma'am, for your truly enlightening and knowledgeable words. Let's now invite, with utmost ecstasy and respect, Dr. Bhargav C. Patil, sir, Senior Assistant Professor, National Forensic Sciences, University, Ministry of Home Affairs, Government of India, Gandhinagar, Gujarat, for the felicitation speech. Sir, please.
Am I audible?
Yes, sir, you're audible.
Okay. First of all, I'm really thankful to invite me in the crowd of this, legendaries, because I feel that I am really out and odd person here. I'm a very small person, a small researcher, active researcher in the forensic community, and I got this opportunity to share a few words here, right? So first of all, I'm really thankful to Dr. Pillai, Dr. Jacob, Dr. Nirla, and Dr. Sindhu madam, right, for giving such a wonderful background and wonderful different aspects of forensic science. One thing that I must tell that it is always delightful when lawyers are talking about forensic science. It is a very rare event. When I started my career in forensic science in 2012, since then, I think this is the first event that it is solely organized by lawyers based on complete aspect of forensic science. This is really a wonderful event. Whatever the problems that Madam has described just before, right? Don't you think that considering this problem, right, nothing is left? It means there are a lot of things which are yet to be done, and regarding the forensic science is concerned, because after listening this speech, I think that I should not sleep. I should always be working 24/7 to solve these problems, right? Because I'm basically from a molecular biology background, forensic geneticist, and whenever the name DNA comes, so basically it is considered to be the gold standard, right? But when the Innocence project was launched in USA, later on it was realized that none of the scientific method is foolproof. None of the scientific method is foolproof. And that is the reason why the most important aspect which is missing right now is quality control and quality assurance. And that's why the perfect word is utilized here, that credibility of forensic practices. And that is mainly required nowadays. And India, which is on the verge of implementing DNA bill very soon, right? We know that DNA bill is since many years, I think more than 16 years, this bill is under discussion. But we pray to God that one day it will be passed, definitely. So, but after the bill will be passed, so I think that, are we ready for this particular bill? Are we ready for this? Whatever the legal system. So, Madam has discussed about whatever the bottlenecks are there and which are the challenges in forensic science. And Dr. Jacob has described the importance of forensic science and the lack of that forensic science being applied in criminal cases is really a big gap there, right? So, is our legal system ready to implement this kind of, innovations? Because nowadays we have, crossed the things. For example, Alex Jeffrey started with VNTRs. It was a gel-based system, and it was on completely gel-based system. And nowadays the world is talking about genetic genealogy, which is one of the wonderful tool nowadays. Just like a social platform like Facebook, genetic genealogy is based on completely that social networking aspect, right? DNA fingerprinting, all that. So are we ready for that particular implementation of such kind of technologies? So for that, I think, this is a wonderful platform that all lawyers have gathered here. And there is a a proverb, or you can say a simple rule, common rule, the demand and supply, right? So until and unless the justice delivery system will not demand, the supply will not be there. So that's why I'm telling you that there should be a complete emphasis, or a very forceful emphasis, on quality control and quality assurance should be there, so that the quality of DNA profiling, quality of physical science, maybe fingerprint, maybe ballistic, maybe narcotics, maybe any scientific method, that should be a strict guideline for that particular thing. I'll tell you that in India right now, we are following all the international guidelines, but there is no independent guidelines which are there based on that we can realize that this is our national guidelines on maybe DNA fingerprinting, maybe physical evidences, maybe chemical evidences, and nowadays cybersecurity. The lots of things are being done. NFSU, National Forensic Sciences University, only university in India which is dedicated to forensic science, and nowadays it has elevated as a central university and institution of national importance. So I definitely can assure that yes, many of the questions which are being raised by Madam and Dr. Jacob is being addressed right now at NFSU for the national cause. We are working on that aspect, but NFSU is not enough, right? We require the support of each and everybody who is involved in justice delivery system. And I think by this kind of seminar, by this kind of the gathering and you can say brainstorming sessions between the forensic scientific community and the actual implementer, that the judges and the lawyers should think about this. And definitely because of this only, right, the proper implementation of the scientific technologies, or you can say and Dr. Jacob has mentioned about rightly that only 1 or 2% cases are being handled forensically. This is really a reality, right? Even the developed countries are also facing this problem. We can understand that developing countries will face this problem, but right, this is not the era to think about that. Okay, we can't do, but we can do that. And it's not only negative things. I'll tell you that Bangalore is the first city to implement 3D barcode system, that QR code system for chain of custody. It was a really delightful news when I heard about that. The few Karnataka officers came here in NFSU for 3 months training. They are newly recruited persons, and I was very happy to see that. Right, all the DNA experts who joined that particular brigade in Karnataka right now, they all are doctorates. They all are, they have completed their PhDs from very premium institutes like IISc Bangalore and all that. So it is really you can say very hopeful condition that yes, the forensic science system of our country is going to be revolutionized and modernized very soon. And there are lots of changes which are coming in the in the condition of just whatever the current justice delivery system of India, and lots of big changes are required, and definitely together we will be able to do that. And the education system, the research and training, these are the 3 aspects by which we can cover up this particular problems, and we can definitely give solutions to this kind of problem. You will be surprised to know that yes, the Jammu laboratory, Jammu FSL lab and Haryana has already implemented LIMS in that particular forensic lab. So laboratory information management system is already applied that. So see, this is really a wonderful thing, and all justice delivery system people must be knowing about that. This kind of system is being applied. And the most important part, which is still neglected, is the crime scene management. So the madam has rightly said, the collection, preservation, transportation, right? These 3 aspects are most crucial part, because none of the laboratory in the world is existing which can find out the DNA from the degraded samples. It means, I'm not telling you that it is not possible, it is possible, but unless you are not handling the crime scene samples properly, then what the laboratory people will do? If you are, it's just like GIGO, garbage in, garbage out, right? So the first thing that yes, crime scene management must be there properly managed, and the collection of the samples. It means each and every police personnel who is going to that. I appreciate the right now I think 2 weeks back I show the advertisement from, I think, Kerala government that 250 crime scene officers are being recruited in the police force. So this is called, you can say, the first, and you can say the very forward thinking that yes, this kind of expertise are required in the police force. Not only forensic laboratory, but the police force required this kind of experts who can collect the samples, who can collect the correct samples, who can collect the correct sample, who can preserve the sample properly, and then they can send. Right. So this particular area is still full of question marks. So that's why we should consider and we should concentrate on these aspects. And what Madam said, that procedural laws. So there are lots of things to be done. Right. I think miles to go away before we sleep. So that's why this kind of seminar, not only seminar but the execution. But after this, whatever the implementation, we should believe in applied philosophy. Right, not just by preaching, but by implementing this kind of things in our laboratories. I think we can do wonders. So I think this was the thing that I wanted to tell, and I'm really happy that yes, lawyers are also sincere about the forensic science in this way. So definitely, the future of forensic science is very, very bright in India and as well as in neighboring countries like Sri Lanka. So thank you so much once again that inviting me in this particular very eminent crowd. And I'm really happy to be a part of this particular team. Thank you so much.
Thank you so much, sir, for your valuable words of wisdom. Gratitude is not only the greatest of virtues, but the parent of all others, says Cicero. I now invite a vibrant faculty with an illuminating personality, Ajita Nair Elmam, Associate Professor, Kerala Law Academy, for delivering the vote of thanks. Ma'am, please.
Thank you, Gauri. Respected dignitaries on and off the virtual dais, teachers, students, participants, ladies and gentlemen, a very warm and cordial good afternoon. Today in this 10th International Seminar on Credibility of Evidence by Forensic Practices in Crime Investigation, the duty assigned to me is to deliver vote of thanks to the esteemed personalities who have become the part of our today's program. Before entering into my duty, I would like to use this opportunity to pay homage to our great Guru, Dr. Narayan Nair Sir, the founder and the former director of Kerala Law Academy Law College. It is my honor and privilege to deliver vote of thanks on behalf of one of the prestigious institutions of our country, that is Kerala Law Academy Law College. First of all, I would like to use this opportunity to deliver vote of thanks to Dr. Sindhu Tulasidaran, Head and Associate Professor of Law Department, University of Kerala. Yet he is the head of the department. He is so simple and accessible. She is facile and intelligible. The speech delivered by her is so informative. She has beautifully explained the happy blending of forensic science and law. So I express you, ma'am, a sincere vote of thanks on behalf of me, on behalf of Kerala Law Academy Law College with culture, and also on behalf of all those who are present here. Then I would like to use this opportunity to deliver vote of thanks to our Honorable Vice Chancellor, Dr. V.P. Mahadevan Pillai Sir, University of Kerala. We are really blessed with the majestic presence of our Vice Chancellor. The speech delivered by him was so informative. He has explained the role of evidence in crime investigation in a beautiful manner. So I express you, sir, a heartfelt thanks on behalf of me, on behalf of Kerala Law Academy Law College with culture, and also on behalf of all those who are present here. Then I would like to take this opportunity to deliver vote of thanks to Dr. Alexander Jacob Sir, IPS, retired DGP in Kerala Police. He is a person of having efficacious and effectual charisma in his career. The readiness showed by Sir to share his knowledge and experiences with us in today's program is really laudable. So I express you, Sir, a sincere thanks, a deep and devout vote of thanks on behalf of me, on behalf of Kerala Law Academy Law College, Mythical Sir, and also on behalf of all those who are present here. Next, I would like to take this opportunity to deliver vote of thanks to Professor Trivandrum, Faculty of Law, Department of Public and International Law, University of Colombo. Ma'am, the speech delivered by you is really informative. She has explained beautifully the serious issues in the applicability of forensic evidence in crime investigation. So I express you, ma'am, a sincere thanks on behalf of me, on behalf of Kerala Law Academy Law College with Culture, and also on behalf of all those who are present here. Then I would like to express my sincere thanks to Dr. Bhargavasi Patel, Senior Assistant Professor, National Forensic Science University, Gandhinagar, Gujarat. It is quite a matter of happiness and a pleasure that a great personality from a forensic science university to be with us in this program. The speech delivered by Dr. C. Bhargav Patel is quite informative and inspirative. So I express you, sir, a sincere thanks on behalf of me, on behalf of Kerala Law Academy Law College, with the culture, and also on behalf of all those who are present here. Next, I would also like to use this opportunity to deliver vote of thanks to Advocate Nagaraj Narayan sir, who is the young and energetic director of our institution. He is acting in various capacities, such as adjunct professor of Nivals, member of Bar Council of Kerala, and also special pleader in environmental law in High Court. Sir is a man of great ideas, objectives, vision. So we are blessed with having such an excellent director of our institution. So I express you, sir, a sincere thanks on behalf of me, on behalf of Kerala Law Academy Law College with Culture, and also on behalf of all those who are present here. Professor K. Harindra sir, Principal Kerala Law Academy Law College, who is always acting as a source of motivation, driving force behind all the programs being conducted here in our institution. So I express you, sir, a sincere thanks on behalf of me, on behalf of Kerala Law Academy Law College, and also on behalf of all those who are present here. Next, I would like to use this opportunity to express vote of thanks to Professor K. Anil Kumar sir. All the programs being conducted here in our institution, the brain behind those programs is Professor K. Anil Kumar sir. Without Anil Kumar sir, we are nothing. Our Law Academy is flourishing day by day. It is only with the enormous capabilities of Professor K. Anil Kumar sir. So I express you, sir, a sincere thanks on behalf of me, on behalf of Kerala Law Academy Law College, and also on behalf of all those who are present here. Then I would like to use this opportunity to express my sincere thanks to Dr. Dakshina Saraswati, who is an all-rounder in organizing all the programs in our institution, Priya MK, Shalini Epi, assistant professors of our institution, who are also the co-conveners of the program. Then I express sincere thanks to all the teachers and non-teaching staffs who have rendered valuable services in making this event a real one. I would also like to use this opportunity to express my sincere thanks to all the participants and paper presenters from different parts of our country. I express a sincere thanks to student conveners of this program, Ajay, Rishikesh, Nandakishore, Ashik, Sudhi Kannan, Abhirami, Darshana Vikram, Gobika Shashi, Anandu. I would also like to use this opportunity to express sincere thanks to the members of our technical team and also all the students of our institution who have rendered valuable services to make this event a successful and a real one. Thank you.
Thank you so much, ma'am. With that, we have reached to the conclusion of the formal inaugural session. I once again express my sincere gratitude to each and everyone who had attended the inaugural session of this 10th International Seminar on Credibility of Evidence by Forensic Practices in Crime Investigation. Thank you all for your kind cooperation and support. This is SR Gauri signing off. Once again, thank you all. Thank you.